All right, we are ready to proceed with the third case on this morning's docket. It's a case out of Stafford County, number 122-907, entitled Stephen Matisse versus the City of Stafford, Kansas. I see that we have Mr. Rathbun here for the appellant and Mr. Glendenning for the appellee. Counsel, just a few preliminary remarks. We have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. Each of you has 15 minutes to make your argument. The appellant's attorney should let us know at the beginning if you wish to reserve any time for rebuttal. After you make your arguments today, your case will be deemed submitted for decision. And after that, we will get a written decision out to you and your clients just as soon as we possibly can. So with that, Mr. Rathbun, we'll go ahead and start with you. And please let us know if you wish to reserve any time for rebuttal.
Thank you, Your Honor. Yes, I'd like to reserve 5 minutes if I could, please.
That is granted.
All right. I am before you today representing former Chief of Police Steve Mattice, who was the Chief of Police of Stafford, Kansas for about 5 months before he got fired. On December the 7th of 18, he requested a meeting with the city administrator, the city mayor, the city attorney, and the city council to complain about the fact that his interference into allegations of a police officer having sex with a minor was being interfered with. The next business day, city management gave the city administrator the ability to discipline the chief, and the next day after that, he was fired. The actions of the city manager here violated KSA 21-5904A3, which is interference with law enforcement. The city manager thought that this investigation would give her and the city a black eye. They decided to fire him. This is a classic retaliatory discharge. The court dismissed this case before the defendant answered and before there was any discovery in the case. Judge Malone, I don't know if you can recall in our youth, but we had a judge by the name of Howard Klein down in Sedgwick County. And in reading the oral argument on the motion to dismiss, I was reminded of that. In those days, Judge Klein would call you into his chambers after a motion to dismiss had been filed and would ask you, now, how are you going to prove this case, counsel? And would listen to your arguments. And if he didn't think you were going to be able to prove the case, he would just bounce it out. Finally, after being reversed a number of times by the Supreme Court and the Court of Appeals, he finally stopped doing that. But as I looked at this case, I was reminded of that because honestly, Judge Johnson, he made a number of findings that are nowhere in the pleadings. And for the life of me, I can't find out where he came up with this. As this court is well aware, the only facts before the court on this motion to dismiss were the facts as alleged in the petition. Those were the only facts he considered. And if you look at his decision, it's like we had a trial with no jury. He made findings about the credibility. He made findings about whether the city had believed my client, a number of findings that I just cannot understand how he was able to do. Let me focus quickly, if I can, on the issue of our failure to pinpoint. I know that's very important to this court because it saves you a lot of time having to go through the record. The problem is this case was such a dramatic failure of the rules related to motions to dismiss. There is no place in the record that I can pinpoint an error because, as this court knows, under our discovery rules now, under Noel versus Pizza Hut and the Supreme Court Oler case, which we both cited in both. All you need to do is make a bare bones pleading, which outlined the nature of your claim. You don't need to set out a legal theory. You don't require the pleading set forth sufficient a cause of action. You don't have to plead the elements. The spirit of our rules are to allow you to do discovery. You can plead contradictory or alternative statements. And the whole problem of this is the judge looked at facts, weighed those facts, and decided that we couldn't prove our case. And so consequently, the
Counsel, under a notice pleading standard, which I agree with you is deferential and lenient, right?
yes.
But using a notice pleading standard here, could you maybe step me through your petition and let me see what the city was on notice that you were claiming?
Sure. Thank you, Your Honor. I would like to do that.
To verify, can we look at the amended, are you looking at the amended petition, Counsel?
The amended petition, yes.
Thank you.
If you look at the amended petition, you go through, you will see that allegations of Osborne, who was the officer that was allegedly, Osborne's misconduct had been taken to his direct supervisor at the city. Downing downplayed the allegations by saying that the person that had reported it was not a credible action. That those allegations were taken to the KBI. And then if we go on further, we look at paragraph 24. We say that on February the 7th of 18, an executive session was held. And as I've already indicated what happened. 25, Chief Mattice expressed his concerns that his work was being extremely uncomfortable and that his investigation of Osborne and subsequent threats against him and his family was impeding his action of doing this investigation. And so if we look at retaliatory discharge, in this case, we had an officer that made a finding that he believed what had happened here was a violation of Kansas law. He went to the city manager. The city manager said, if you say this stuff, it will hurt my reputation and the city's reputation. He asks for a chance to meet with the city manager, the city council, the mayor, and the city attorney, and says, this is interfering with my ability to do an investigation. And he was fired the next day. That to me is clearly retaliatory discharge. And certainly you don't have to plead all the elements, of course, in Kansas anymore, but that was enough to put them on notice as to what our claim was. At that point,
And
yes, Your
Counsel,
Honor.
in paragraph 29, I see that you said, as a result of his Matisse's reports, I'm sorry, I
Yes.
believe I've said his name wrong. The chief, can you clarify how to, Matisse, my apologies. Matisse's
That's right.
reports that he was retaliated against and ultimately terminated.
Yes.
So that is the crux of your case.
That is,
Matisse's reporting in the various reports noted in this petition, that those reports resulted in the termination of his employment.
absolutely. What's the duty of the trial court in a case like this? The duty of the trial court is to scour the record looking for any possible claim, even if it was not made in the pleadings. I have to agree with defense counsel in this case. I don't think this at the trial at the district court level, this case was handled by an associate who's no longer with the firm. And I don't know that the precise argument was ever made, but to me, this was a clear Connolly decision. Connolly is directly on point with this case. I read the facts of the case and I thought, this is a Connolly case and it's directly on point. I know that my young associate did cite the Connolly case, but I don't know that he made the correct argument as to how Connolly applied to this case. So anyway, I think that it's just as plain as it can be that under notice pleadings, this is a matter that ought to be responded to with an answer, and there should be discovery. So I'll reserve my time, Your Honor.
All right, counsel, thank you very much. Mr. Glendenning, we will turn to you.
Thank you, Your Honor. One thing, there's one part that's easy about this case, and that is that plaintiff does not contest any of the court's actual analysis and ruling in the court below. He does not contest that the grounds submitted and argued to the district court do not support a whistleblower claim. And in fact, I think he just specifically agreed that that would have been a correct ruling in this case if that were the only claim to be made. So at a minimum, this court can affirm what Judge Johnson actually did rule, and that is that the allegations that were actually presented to him do not constitute a whistleblowing case. The problem here is that the plaintiff is attempting to present an entirely different case to this court on appeal than he
I'm
presented
sorry,
to.
counsel. I don't think I understand what you're saying. You're saying that the dismissal of the whistleblowing portion is appropriate because not enough evidence was presented regarding the whistleblowing claim?
No, what I'm saying is that a whistleblowing claim based upon the reports that were actually presented and argued to Judge Johnson, that would be in the district court. What the plaintiff argued was the reports that constitute whistleblowing were, number one, when he reported to Downing about Osborne. Number two, when he reported to Downing a worry that one of his subordinates was interfering with his investigation. And number three, when he reported to the city council that he was being unprofessionally chastised and that accusations had been made against him and his family about neglecting their own child.
And so, counsel, are you contending that at this juncture in the dismissal stage that it was plaintiff's responsibility to include all of that in the petition and in the response to the motion to dismiss, like every fact of the case?
No, what I am alleging, or what I'm arguing, is that it is his responsibility to submit sufficient facts to support a claim, and that he also has some responsibility to make an argument to the district court. He can't come to this court later and raise a whole new argument that he never gave Judge Johnson a chance to rule upon. But more importantly, the problem is, and I think this goes back also to the first question that you asked, is that the allegations, the factual allegations that the plaintiff is relying upon in this appeal are nowhere found in the record below. He did not even allege those facts. In fact, he alleged contrary facts, because in this case, he is now saying, I blew the whistle when I went to the KBI and said Downing is interfering with is ordering me not to enforce the law. Go back and look at his amended petition. Go back and look at all of his facts listed in his brief. Nowhere does he say, I reported to the KBI that I was being ordered not to enforce the law. What he says is,
Counsel, I interpret the argument a little bit differently from that. I interpret the argument to be that I requested a meeting with my immediate supervisors to talk about the investigation and the problems with the investigation that I was receiving from the city. And then shortly thereafter, I was terminated.
That is one of the arguments that he made below.
And isn't that under a motion to dismiss standard, isn't that sufficient to get us past dismissal stage?
Not as he presented it below, because what he presented below was that what he told the city council was that I'm being unprofessionally chastised and complaints have been made against my employer. He did not say, I have been ordered not to enforce the law. That wasn't his complaint below. This is an entirely new complaint. This whole idea that he's trying to fit within Connolly is an entirely new complaint that he never made below, and the facts supporting it were not even made below. If you look at his
But
actual
under the
allegation,
motion to dismiss standard, aren't we supposed to, isn't the district court under an obligation to see whether there is any claim that can be stated by way of the allegations in the petition? And if there are any claims that can be stated, then that's enough, right?
but not to the extent that plaintiff can say, here's what my claim is, judge. And when the judge says, no, your facts don't support that. And then he comes to this court and says, I've got a whole new idea, a whole new argument I never gave Judge Johnson a chance to rule upon. If the problem with this argument that he's trying to make is, yes, the judge has an obligation to look at the allegations and see if there's any theory, but that doesn't mean he has to become the plaintiff's advocate. That doesn't mean the plaintiff can say, here, judge, here's all the facts of my case, find a theory for me. And then when the judge says, well, I can't find one, then he comes to this court and he says, I came up with one after the judge ruled that I didn't give that judge a chance to rule upon. Now you need to reverse it and send it back. He still has some obligation to make an argument and preserve an argument for appeal. The way the plaintiff wants to read that rule that the judge should look at the record, look at the pleadings and be liberal in determining whether or not there's a claim doesn't eclipse the requirement that you have to make an argument to that judge before you can come to this court and say, he messed up because he didn't come up with an argument I didn't come up with based on facts I never told him about. That's the problem. That's the failure to preserve argument that I'm making in this case.
So you're making an argument that there's a failure to preserve the claim, the allegation that he went to the KBI with a complaint.
That he was told not to enforce the law.
I see. So you're specifically saying he has not preserved something related to Connolly. In the petition here, it says that he went to the mayor, the city administrator, etc., and then was fired a day or two later. Are you saying that that's not an allegation of retaliation?
Oh, it's definitely an allegation of retaliation, but it doesn't implicate whistleblowing. As Judge Johnson ruled, that kind of internal debate between an employee and a supervisor about what he should spend his time investigating and what he shouldn't on an old claim that had already been looked at and dealt with years before.
To me, what it sounds like, though, is that the judge was analyzing the facts as it relates to those allegations, like in a summary judgment.
I think he was taking the facts as they were alleged and saying, this is a dispute with your employer about internal operations. This does not implicate whistleblower protection.
So there was a report internally, and you agree that an internal report can be a whistleblower action, correct?
That's correct.
And there was a report regarding a violation of rules, sex with a minor.
But it wasn't of a co-employee or the employer on an ongoing basis. It was an allegation.
Then your contention is that you cannot whistleblow on a prior bad act.
Not under the circumstances as alleged in this case, because if you say that is whistleblowing in this case, what you have just said is, anytime a police officer says, I'm going to investigate a certain crime, and his supervisor says, no, that's an uncredible claim. It's already been dealt with. Spend your time on something else. He can then go complain to somebody that he's been told not to enforce the law. And suddenly, if he's terminated because he's not obeying his superior's instructions as to where he should focus his efforts when he's on city time, that suddenly the jury gets to second guess whether or not he should have been told to not investigate that old past crime and that allegation that lacked credibility.
And
that's just not whistleblowing.
Is that specifically related to police officers? It's like a public policy reason for not finding that to be whistleblowing?
I think it certainly, I think it could relate to others as well, but it certainly applies to police officers and public employees in general. That's the Garcetti issues that I raised in my brief, where those are First Amendment cases, but those concerns are the same. We want people to blow the whistle when there's a reason to blow the whistle. We want people to have their right to First Amendment, but there also comes a point at which we need to be able to supervise public employees and give them direction as to what they spend their time on. And this case is This case is nothing like Connolly.
Right,
Connolly,
and-
oh,
And I'm sorry, I'm not saying that it is or isn't like Connolly, but I'm curious though, because this is a lot of analysis that has gone into that at a motion to dismiss stage. And so I'm just having a little trouble with understanding how all of that analysis fits into a motion to dismiss analysis.
okay. I think I understand the question. And obviously kind of maybe to bookend it with some extremes, a person could not come into the court with an allegation that my boss retaliated against me because of something I said or did, and not have to, at that stage, make an allegation that that something he did or said actually fits within what constitutes whistleblowing. He can't come in and say, I complained to the boss that we don't have Diet Dr. Pepper in the refrigerator, and then I got fired. Because at a motion to dismiss stage, you can say, no, that's not whistleblowing. And that's true in this case, because what he has come to this court with and what he came to the district court with is an allegation that he was given direction from a supervisor about where he should spend his investigative time. He did not allege anything that constituted an ongoing violation of the law by a coworker or an employer. It just doesn't rise to that magnitude. What he was told was, and he wasn't even ordered not to do it, he was told that's an incredible claim. Spreading that around is causing harm to the city because false accusations of a serious nature are being made against a man. And I discourage you from doing that. Even taking that at face value, or even taking at face value that she just flat told him, don't investigate that, spend your time on something else. My argument is that as a matter of law is not sufficient to state a whistleblower claim. For that reason, a motion to dismiss is appropriate. We should not require cities and law enforcement agencies all over this state to go through discovery every time a law enforcement employee says, I was told not to investigate an old claim. And yet that is what would happen if we don't use the motion to dismiss at this point and say, no, when that's your allegation, that isn't sufficient to raise a claim as a matter of law, even if it's true.
And that's because it was a former employee and the allegation of rape was not ongoing.
Right. It's a former employee. It wasn't an ongoing crime
Right.
or a problem. And this issue doesn't even rise to that magnitude because the issue is an internal operation. Should you investigate that old claim or not? Should you spend your time on something else? That's just
I'm
not
sorry,
the
I
kind
don't
of
understand what you mean by an internal operation.
when a superior tells a law enforcement officer, don't investigate that old claim, spend your time on something else. If that officer can say, sorry, I want to investigate that, and if you tell me I can't, I'm going to sue you because I blew the whistle on you for telling me not to enforce the law.
So are you
Then
saying it would be the same as if the officer was wanting to investigate an external claim? This is an internal claim.
Well, it's actually an external claim at this point because it's no longer a police officer. He's no longer an employee.
But
He's
the
off in another
allegation
agency.
occurred, the allegation of rape was while he was a police officer.
Right. But if you want to say that because he was an employee at the time, and actually I don't think it was necessarily an allegation of rape, but if you want to say that's internal because it was back then we have even more of a problem that it isn't an ongoing problem right now with a co-employee or the employer right now. It's
Do you have a
just
citation? I'm sorry, counsel. Do you have a citation for the fact that it needs to be an ongoing action in a whistleblower claim?
Yes, Your Honor, it's in our brief. I think the way it's put is that it has the purpose. Here it is. It's Shaw versus Southwest Kansas Groundwater Management District.
Mhm.
It's on page 10 of our brief.
Okay.
The way the court put it is the whistleblower must seek to stop unlawful conduct through the intervention of a higher authority, either inside or outside the company. Saying I want to investigate an old past claim is not seeking to stop unlawful conduct through the intervention of a higher authority.
Counsel, can I come in for just a second and bring this back to the petition and the motion to dismiss? I'm wondering, it sounds like your argument is that with retaliation claims against city officials or government officials or law enforcement officers, that we ought to read into that a particularity pleading requirement. Did I misunderstand your argument with regard to that? And if not, straighten me out.
No, I don't think you have to have a particularity requirement, but you do have to state a claim. You have to at least, you can't just say, I was unhappy with my boss, I got fired. That wouldn't state a claim. You have to say, what were you unhappy about? And then that something you're unhappy about has to actually state a plausible claim. It isn't enough to say, I went and talked to the city council, my boss is mistreating me, I don't like what she's telling me to investigate or not investigate. That, even if it's true, I mean, that's the purpose of a motion to dismiss, is to say, take that all as true, it's given. Now, does that state a claim? No, it doesn't. I don't think you can go the extra step that I think the question might imply that I would be concerned about. And that is, he can just come in and say, I'm unhappy because my boss fired me because I complained about my boss. Now, I've pledged no other facts. Let's go do some discovery and see if I can find facts to support a theory. He still has to have some kind of facts that create some kind of plausible claim. And if you say that all he has to allege is I was fired when I complained about my boss without any reference to what he complained about, then we no longer have employment at will, or at least employment at will has been eviscerated to the point that you do have to go through full litigation and full discovery before you can get to a determination that no, there's nothing here. Every firing can be reviewed by full discovery and the full weight and cost and expense of the judicial system, just by saying I was fired because I complained about something the boss did. You have
2 minutes, counsel.
Okay. You have to state a claim. You have to state enough facts that says, yes, this is a claim, not just my claim is that I want money from the boss because they fired me. Now we'll worry about the facts later. And the facts that have been stated in this case didn't constitute whistleblowing. And in fact, plaintiff concedes that by saying that he agreed that what was argued below isn't sufficient, and by not even trying to defend or oppose the decision that Judge Johnson made about the facts as they were alleged. Instead, he comes to this court and says, no, this is a Connolly case because I was given an order not to enforce the law, and I reported that to the KBI. But those facts are not in the petition. They're nowhere in the record below. And even if you take them at face value and consider this, if you say, okay, I'm gonna let that be sufficient, that isn't sufficient on its face. The Connolly case involved officers being told in advance, don't enforce this law against anybody in this particular class. And that's going forward, and that's affecting public safety going forward, because that's saying those guys can violate the law now with impunity and we will do nothing about it.
But counsel,
that's not what happened here.
Counsel, is there not a rule or public policy that police officers should investigate and report allegations against police officers? So let's say your theory that you can't whistleblow on a murder, for example, because it's already done, is true. What about the fact that there would be a requirement and a policy for supervisors and police officers to investigate a murder? That would be ongoing, right? I mean, would you consider that to be an ongoing violation?
No, because that's the problem. It's not a question of whether there is a murder. It's a question of, was there even a crime? And the plaintiff in this case specifically alleged that he wasn't even convinced. He didn't say, I mean, he doesn't even meet that requirement of a whistleblower complaint that's a reasonable person would think there was a violation. He says, I was unconvinced and I had a conflict of interest to even decide that, so I pitched it to the KBI. And when law enforcement has all these complaints coming in, an old complaint from an uncredible source, and then they're making a decision, what do I spend my time on? The supervisors get to make that decision. And for an officer to be able to say, I'm whistleblowing when I say, I disagree with your decision about what I should investigate, I'm going to go do this. And the boss says, no, you're going to go do that or you're fired. According to plaintiff's theory, he now has been ordered not to enforce the law, and therefore he has a whistleblowing claim. That's not what whistleblowing is about. It isn't to
So
govern
this
the internal procedures.
It sounds like there would be a slightly different standard for police officers with regard to the whistleblower statute.
I think the same thing would apply to any employer when when it's an argument about what we spend our time doing. I think I should spend my time doing this. The boss says, no, do this. Well, I'm going to blow the whistle by saying that the boss is saying I shouldn't look into something, even in the private sector, that might have something to do with safety, OSHA complaints, whatever. It still boils down to when it's an internal issue about what we investigate, what complaints, not what we've actually observed, but what old complaints we get, how incredible they are. The judge.
Sorry, counsel, that's an error in the computer system. That was not me. I apologize.
No problem. The supervisor gets to say how we do that. And whistleblowing is supposed to be a limited exception to the at-will employment, not something that an employee can use, particularly not a public employee or police officer, use to direct his supervisors as to what they're going to let him investigate and what they aren't. That's just not whistleblowing. There are other remedies for that. If you want to take that up politically, that's fine, but it doesn't amount to whistleblowing when a supervisor tells a law enforcement officer, that's an uncredible complaint, don't spend your time on that.
All right, counsel, hearing no further questions, you've used your time. So Mr. Rathburn, we will turn to you again. You still have your 5-minute rebuttal.
Thank you, Your Honor. This reminds me of, I guess, well, it doesn't remind me because it didn't do it, but in 64, we had what was called the field code. And anytime you wanted to plead a case, if you had to plead a case, you had to try and decide whether you were going to plead it as a trespass query clausum fragate or trespass de bonus aspertatis, because in those days, you had to clearly plead each element under the Latin requirement. And if you didn't, then your case got it knocked out. Luckily, those days are so gone. They are so over with. That is not the law. The plaintiff is not required to plead the elements of a claim. All you have to do is put them on notice. In paragraph 24, the plaintiff specifically alleged that on December 7, 2018, an executive session was held at the request of Chief Mattice between himself, the city council, the mayor, the city attorney to address Chief Mattice's concern over the issues arising out of Clayton Osborne investigation. I don't know how you can state that claim much more plain than that. Now, I don't know what to make of this allegation that it must be an ongoing action. And let me dovetail a little bit on Judge Hurst's question there. For instance, if the city manager's brother robs a bank and the next day the police chief goes to the city manager and says, hey, I think your brother was involved in that bank robbery yesterday. And she says, well, I don't think you'd ought to investigate that, and fires him. Who in the world would argue that that was not a retaliatory discharge? It was a past event. Virtually everything law enforcement does is investigate past events. In the Connolly case, the officers went and complained about the fact that the head of the highway patrol had told them not to enforce the laws against the farmer on the weight restrictions on truck, which had happened back during harvest. I think what counsel for the city says is by calling these old, that means anything that hasn't already happened. How can you be retaliatory discharged for investigating things that haven't happened yet?
Counsel, I was wondering if you could address the argument by your opposing counsel with regard to the fact that, if we were to hold that a claim had been staged in this case, then that would open the door to essentially any claims that, by any police officer anywhere, if their supervisor said, don't spend your time investigating that particular issue.
I think I don't agree with that parade of horribles, and here's why I don't. In this case, we had the chief of police telling, and his direct supervisor telling him not to do that investigation. That is a specific violation of Kansas law. Now, in a normal case where someone in the police department tells someone, you know what, we don't have the manpower to investigate that, move on. That is not a violation of 215904. In this case, this was a precise violation of that, in which he was instructed not to follow up on that. And
where
that's why.
During a case would we ferret that out? Would that be something that we would determine at the pleading stage, or is that something that we would determine at summary judgment? Is it something that would have to go to trial every time?
No, I don't think so, but certainly the court always has to be mindful of its obligation under a 6212B motion to dismiss. In this case, I tried to write down every time that Mr. Glendenin said all these things happened. Half of this stuff we were talking about wasn't in the record. I mean, we kept talking about, well, the plaintiff's counsel got the chance to address these arguments during the oral argument with the court. Well, this is a motion to dismiss. There hasn't been any discovery. You have no obligation to know what the facts are at that point. So, Your Honor, I don't know if there is a time point that I can specifically point at. I know that the rules of procedure are plain. The plaintiff has only to make bare bone allegations, and the defendant has to answer at that point, and then you can do discovery. I don't know how that's different than any other retaliatory discharge case filed. I've been doing them for a long time, and that's a standard in every case. I can I can tell by the way you're looking at me, Judge, I may not have answered your question, but I don't really know how to. This parade.
I don't have the answer either at this point, but I was hoping that you might.
This parade of horribles applies in every case. I mean, everything you file on a retaliatory discharge, that argument can be made in every case. I have nothing further.
All right, counsel, hearing no further questions, we thank you very much for your briefs and your arguments. This is indeed a very interesting case. We will get a decision out to you and your clients just as soon as we can. And with that, this